One of the most common misconceptions about probate real estate sales I often hear is that buyers have to be all cash and non-contingent with their offers. And that's simply not true. In today's video, I'm going to break down what types of offers are actually allowed in probate sales and what sellers are really looking for. Whether you're a fiduciary reviewing offers or a buyer trying to make a competitive offer, this will help you understand what's possible and what's not. If we haven't met, hi, I'm Andrew Vries. I help professional and family fiduciaries sell probate and trust real estate in the San Francisco Bay Area with less stress, less liability, and for more money. I've closed over 900 of these transactions over the past 20 plus years in the Bay Area. And with this channel, I'm here to help you avoid costly mistakes. One of the most common myths I hear in probate real estate is this: buyers have to make an all-cash, non-contingent offer to buy a probate property. And I get why people think that. They hear probate and they assume a rigid, court-driven process where there's no room for anything but cash and no flexibility allowed. But that's simply not true. In today's video, I'm going to walk you through what's actually possible when it comes to making or reviewing offers on a probate or trust property, whether you're a buyer, a fiduciary, or someone just trying to understand how this works. Because if you're basing your strategy on myths, you could be leaving money or opportunity on the table. So let's start with the big questions I hear from buyers all the time. Can I use a loan to buy a probate property? The short answer is yes, you can. In most probate and trust sales, especially when court confirmation isn't required, buyers can absolutely use traditional financing. A conventional loan, an FHA loan, a VA loan, or even a jumbo loan can all be used as long as the property qualifies and the buyer's lender is prepared. Now, where this myth tends to take hold is in court-confirmed sales, which have a different structure and timeline. These happen when the estate is under limited authority and the court must formally approve the sale. This is where things get tighter. For court-confirmed sales, the buyer typically needs to A, put down a 10% deposit, B, wait for a court date, and C, be prepared to close quickly, often with little or no flexibility in timelines. In these cases, financing can still work, but it has to be rock solid. Your lender must be familiar with the probate process, move quickly, and meet the close of escrow deadline, which is generally 30 days or less after court. If they can't, you risk losing your deposit or losing the deal entirely. So again, financing is allowed in probate real estate, but the structure and feasibility depend on whether the sale is subject to court confirmation and how strong your financing terms are. For buyers, make sure your lender is on board and understands the process. For fiduciary sellers, it's not about whether the offer is cash or finance, it's about whether the buyer can actually close and close on time. Now let's talk about contingencies, another area where there's a lot of confusion in probate and trust sales. Can you include contingencies in a probate sale? Yes, absolutely. Just like in a standard sale, buyers can include financing, inspection, or appraisal contingencies. These are basically protections that give the buyer time to verify key parts of the deal, and in some cases, to back out if things don't line up. For example, a financing contingency allows the buyer time to secure final loan approval. An inspection contingency lets them assess the condition of the home. These are normal tools buyers use to protect themselves. But here's where things get more nuanced, especially in a competitive market like the Bay Area. Fewer contingencies generally means a stronger offer. Why? Because from the seller's perspective, especially a fiduciary, contingencies equal uncertainty. And fiduciaries, by definition, are tasked with managing risk. They're responsible for closing the transaction cleanly, efficiently, and in the estate's best interest. So for a fiduciary, it's not necessarily about choosing a cash offer or an offer with less contingencies. It's about choosing the offer that is most likely to close for the highest sales price with the least chance of falling apart halfway through. If you're a buyer, that doesn't mean you can't include any contingencies, but it does mean that you need to be thoughtful and, if possible, consider limiting your contingencies where you safely can. Keep your timelines tight and make sure your offer tells a clean story. such as, we're serious, we're ready, and we're not going to drag this out. And again, if you're a fiduciary reviewing offers, the goal isn't always to take the highest number, it's to weigh the price and the terms together so you choose the strongest offer both in price and terms with the most reliable path to closing. Every now and then someone asks me, can the estate carry back a loan? Can the seller finance the purchase? And the technical answer is yes, it's possible. Seller financing, also known as owner carryback financing, is a legal option in real estate. It means the seller, rather than a bank, acts as the lender and the buyer makes payments over time. But here's the reality. In my experience with probate and trust sales, this is extremely rare. Why? Because most fiduciary sellers, whether they're professional trustees, conservators, or family members, are trying to do one thing, and that's liquidate the asset. The goal is to close out the estate or trust, distribute the proceeds, pay off debts, and move on. You're not in the business of becoming a lender. Most importantly, a trust or conservatorship can't or shouldn't likely take on that kind of long-term financial relationship. It adds complexity, risk, and ongoing management to an estate that's supposed to be winding down. The only cases where I have seen a trustee consider carrying back a loan for a sale is where the property was unique and difficult to finance, such as a rural ranch. And in that case, the beneficiary of the trust was younger, and the trust was tasked with generating income for that beneficiary over a long period of time. So while seller carryback financing is a real tool that can be used in certain types of real estate transactions, it's likely not a practical or advisable option in most probate and trust sales. Therefore, if you're a fiduciary being pitched on carryback financing, it's worth talking it through with someone who understands the legal and financial implications before moving forward. In conclusion, let's bring it back to what really matters in a probate or trust sale, what the seller and the attorney are actually looking for. First, it's not just about price. It's about the overall strength of the offer. Is the buyer solid? Is the financing reliable? Are the timelines reasonable? And most importantly, is the deal likely to close without unnecessary risk to the estate or trust? So to wrap it up, no. Probate and trust sales are not automatically cash only. Financing is allowed. Contingencies are allowed. And while a clean offer can make a big difference, there's no one-size-fits-all rule. The key for fiduciaries is knowing how to evaluate offers based on the specific situation, legal authority, and the goals of the estate or trust. If you're contemplating a fiduciary real estate sale in the San Francisco Bay Area, please call me today for a free consultation of your estate and trust real estate portfolio and what the best course of action may be given the needs of your unique situation. For more information on our services and recent sales, please visit probateagent.com and subscribe to this channel.